Johnson was part of it. But there's a shakedown going on, family members trying to get people out of jail. We know Robert was looking into that because one of the things he done was in January 2016, take before the grand jury this lady named Tracy Chandler. She makes, I don't know Ms. Chandler, this is an exhibit you look at, D54. She makes some very serious allegations in there about who all was involved in the scam. But the trouble is, she doesn't know. She's just dealing with criminals. You know, somebody's come to her to shake her down for money. And she makes the claim that they're telling her the Dixie Mafia is behind it and they're trying to get Alexander in the district attorney. Now, I can't tell you that's true. I don't know. But I know that's what she said. And it would be concerning to me if I was Robert Smith. And he's looking into it. And he's asking, I asked Beasley about this, wasn't Robert calling you about this scam going on? And he basically denied it. And I asked him about them having words and getting mad at each other about why the Attorney General wouldn't keep him informed or wouldn't let him know what they know about it. And we look at this. He sees Robert is apparently sent an article in the paper about the Attorney General or something about it. And he starts this email chain where they really call each other bad names. And this is what's going on between Beasley and Robert. For all these bad names, and he's trying to find out, you know, what do you know about it? I don't know about it. If you look in Exhibit 30, there's a lot, I know it's a lot to go through, but several times Robert asked Johnson, I keep hearing that you're involved in something. Are you telling me you're not? Is this just rumors? Just like they'll say things about me, they'll say things about you. So he's trying to find out. And he's trying to find out from the Attorney General. That's his job as district attorney. There's a scam going on, he needs to know about it. And they won't cooperate with him. They won't talk to him. And so they have those really horrible words about it. And we had Robert, remember we had the U.S. Attorney come over and show you these texts where he had, Robert had written the U.S. Attorney an email. I keep getting information that someone in this office is under suspicion. Is this just a bad rumor? I want you to cooperate with me, tell me. So he's trying to find out from the U.S. Attorney. But apparently, the FBI and the Attorney General has got the FBI involved in this, trying to make this thing work. They won't cooperate with you either. Don't tell me. I want to mention this. They say Robert interfered because he went to the preliminary hearing. This was the Attorney General's case. If they have the right to go present a case against Butler, the grand jury, they don't have to have his permission to interfere. This is Exhibit D49. I'm sorry, I think that's a long number. But we have the preliminary hearing here. It's in evidence, and you can read it all. And as much as you feel like you can put up with reading. But you remember Mr. Knott said, Mr. Knott testified that I went to Robert's office and I told him that basically, with my understanding, the Attorney General can't prosecute a case without notice to the district attorney. This is his district, his county. And he talks about a case called Williams v. State. That's all discussed. And he asked Robert, will you go over there and just confirm to the judge that you didn't know anything about this, so they haven't given you any notice. And Robert went over that. But by this time, when Robert learns about this, he's angry. And the reason he's angry is because they've been doing this investigation of Butler and where the drugs were planted. And Butler's been making these claims that they were. And then suddenly, with all this going on, Butler gets indicted for something else. Of course, they're right. Robert didn't know a thing about it. He didn't know whether Butler scammed Megamatics or not. He doesn't know scam against finance companies, I think is what the document shows, or if he wasn't what the attorney described, or whatever it was. Robert didn't know. But he's upset. Here's this fellow claiming the narcs are playing drugs, and the Attorney General's office suddenly is charging him with something else without even notice to me and me know anything about it. And he agrees with the defense attorney under that Williams v. State case, you can't do it. That's all that happened. Now listen, disrupting a proceeding. I'm fixing to tell you this, and I'll put all this down the side. Robert's got a few things I want to tell you. Robert, it's true that it was the Attorney General that was bringing the charge. And Robert was a district attorney. And they've got a statute that says, yes, the Attorney General can do that. So Robert, they're going to say, was hindering their prosecution. Now think about this. As you watch this trial, how many times have you seen an interruption in the proceedings by some lawyer, legitimately now, I'm saying this is appropriate for gentlemen, when they're not really parties? This case is between Robert Smith and the state represented by the Attorney General's office. But we have lawyers coming in here. Are they interrupting the proceedings when they tell their clients not to talk, not to answer questions? I want to ask you a little bit now. Please understand this. These lawyers are doing legal things. I'm not saying what they're doing is illegal, but I want to talk to you about why they did it. There's certain privileges a witness has. For example, attorney-client privilege. When I got on the stand, I could have said, I'm not telling you a thing about what Robert Smith told me. I claim the attorney-client privilege. I didn't have to tell him a thing. So I said, okay, I don't need the privilege. I'll just tell you what happened, what I know about what Robert told me. Let the truth come out. But other witnesses chose to claim that privilege. I called Mr. Butler up here. I never met Mr. Butler. All I know about him is what Robert's told me. And I wanted to find out from him, have you been read? What's going on here at the jail? Did they tell you that you get out of jail if you're giving something on Butler? Is that true? Have they come into jail and roughed you up? Have they been moving you around from place to place? I had questions I'd like to ask him. And his attorney came and said, we claim the Fifth Amendment. We don't answer any questions. He had a right to do that, didn't he? But let me ask you, why would he do that? Why would that incriminate Mr. Butler? That's not a crime to be threatened. It's not a crime to get somebody to come in and rough you up. So why did his lawyer tell him to refuse to talk? Because he knows that these fellows right here are holding 100 years over his head. If he says anything to make them mad, he may never get out of jail. And let me tell you something else that really bothers me about this. What's fair and measure in the next several months, I will do something for you. You'll see some reduced sentence, some lesser sentence than 100 years. I don't know what it will be, some amount of years. They'll say, Butler pleads guilty to drug charges. He ain't got any choice. They got him in the noose. And when I see it in the paper, I still won't believe it. Because I know he had no choice. And I don't know whether he did anything or married mattress or not. But I know they got him on a dime and they'll probably have him say it again. Because we know from Henderson that they'll promise him anything. And let me ask you about Judge Will. I know Judge Will has a privilege. It's a different privilege. The judge does not have to explain his rules. He don't have to explain why he rules or what he does. So his lawyer, I don't know if you noticed, gentleman with his lawyer, he's one of the top criminal lawyers for people that's well paid. He's one of the criminal lawyers in this city. He's a very good lawyer. But he was going to make sure Judge Will didn't answer any questions about why he did what he did. But here's a question that Judge Will should answer. Why is it that 2 or 3 days before you were, Robert Smith was going to be arrested, you were keeping Knox, Sanford Knox, and Butler was going to the grand jury? Why were you doing that? And how could you enter that order a day after Robert Smith got arrested if you weren't in on the vote? That's what I'd like to know. I'm going to close. I looked at this jury. I might say, one person that's old enough to remember this. There's a fellow named Waide County.
This time, as this way we need some Kleenex.
This is not evidence, all right? And I don't think it's right.
This was a jury.
What I'm telling you is not
closing argument projection
What I'm telling you is not evidence. I just want to tell you something that was said about Bobby Kennedy at his funeral. He was assassinated. His brother, Senator Ted Kennedy, gave his eulogy. And he said, I don't want to make my brother any bigger in life and in death than he was in life. I don't want to make him something white. I don't want to make him a giant. But I say this, he saw injustice and he tried to stop it. Robert Smith saw injustice and he tried to stop it.
Right now. We've been informed that Mr. Smith wants to participate in this closing argument, and he's entitled legally to do that. Argue the case, but not testify. Right. Proceed, Mr. Smith.
Ladies and gentlemen, I would like to tell you exactly what this case is about in a nutshell. What I'm going to do is start with count 3 of this indictment. I'm going to display it. And it basically cites 97-11-3 of the statute. Now, what they didn't want to show you is what the statute says. The statute says, Attorney General and District Attorney, not to advise or defend criminal bills. Ivan Johnson is a criminal defendant, and they have spent more time with Ivan Johnson than just about anyone else. They went to Christopher Butler, tried to get Mr. Butler to say something. Mr. Butler had more lawyers in the courtroom than anyone else. They were shaking, trying to make sure that he wasn't going to tell you the truth about what really was going on. From 2011 to 2012, when I had no idea about this case, his own lawyer filed burglary charges against the MD.
Sustained.
They had advised numerous criminal defendants just to take me out of office. I've never had a case where a trial is through the Christmas holidays, New Year's holidays, because the objective is that in January, they want to take over the district attorney's office and the will of the voters. That's what this is about. So, while I'm investigating this scam, and I have a right and a duty to the citizens to investigate. And I'm investigating everything possible, and I receive information as you send it from Mr. Stokes, from Councilman Stokes. He received his letter on the night and read it on the radio. Informed me, which prompted me to get a statement from Mr. Butler to put things ahead.
Sustained. Just argue, please.
Yes, sir. You heard testimony from his brother that while he was in his cell, he was tased. What? He was tased in his treatment. That's testimony you heard from his family. His mother testified that she has not been able to see her son. what are behind it. And this Butler case has been on the docket for about 6 years. It's our duty as prosecutors to make sure that these cases move as fast as possible. Not just this case, but every case. The video that they showed you, they admitted were slices, as you've seen in other videos, slices and cut, paste. And then you're, my attorney, asking, why don't you put in the whole video? This is, again, based on the evidence. Our duty as prosecutors, based on Rule 3.8, is to make sure that everyone is treated equally and fairly. This is not just about one person, one defendant charged. This is about anyone, as my letter stated to Mr. Knott. The letter to Mr. Knott is in evidence. You can certainly read that letter, where it is a conversation responding to Mr. Knott about constitutional rights of all citizens. That's another one. The other point that I would like to make as well is that there was testimony that the AG's office was not in contact with Mr. Johnson.
Here's an email, text message. On 6/13/2016, Mr. Johnson was asked, based on information from the office, that Stanley Alexander and Marvin Sanders, seated over here, was in the district attorney's office. He said, yes. I'll call you in a second. But based on their testimony and their presentation, they didn't know anything about Mr. Johnson.
It has just been one line after the other. Just about every witness. Mr. Odom from the Attorney General's office sat here and testified in front of you and said, Ms. Chandler gave Robert Shuler Smith some money. He said, right in front of him. And then I had to get up and show him the report, which was consistent with the grand jury testimony of Ms. Chandler, where she said she paid an intermediary. And then I had to ask him again, so that's not Robert Shuler Smith, correct? And he had to say no, obviously. Well, why did he lie and say yes? I also showed him the timeline between Ms. Chandler paying 2014 to 2015, and then the order signed by Judge Will in 2014. But the point is this. When we deal with cases, if someone writes us a letter and says they have been threatened and coerced, and families come to our offices all the time and say that they have someone who's being mistreated and abused, we have an obligation to look into those allegations. If someone is claiming that drugs or anything else has been planted, and there is substantial evidence, we have an obligation to look into it. We have to look into it. we have a duty and a right to investigate cases and investigate what is going on in our judicial system. And to compromise the cases that Mr. Johnson was over in Judge Will's courtroom just to make me and my office look bad. It's amazing. To allow Mr. Johnson, who was assigned to Judge Will's courtroom, to compromise cases when I'm trying to inquire and find out about this cases.
That last comment is sustained, what he's trying to do. This argument.
So basically, one of the many questions is how much time, effort, and taxpayer resources has been put into this case.
Objection.
All right, sustained.
When we talk about Mr. Butler, as they put in his evidence, free Butler, we're trying to find out from Mr. Butler, speak to Mr. Butler, because as you have heard, he's been moved from one facility to the other. He was a witness. He's a witness. And we needed to talk to him. It was just that simple. And one of my reasons, again, for calling Mr. Waide, was because I felt that
Sustained at this personal feelings and where you go. Sustained.
every district attorney, whether in Hinds County or any other county, we have the same duties and responsibilities. Whether it's to subpoena, to investigate, to look into a case. And again, this case, one of them has been going on for so long with different, really horrible allegations. One of the worst allegations that I can think of is someone praying another. And I think that is certainly something to investigate. The letter that you see in evidence is written to Christopher Butler's lawyer, not Christopher Butler. To Christopher Butler's lawyer, not Christopher Butler. And if you take a look at that letter, you will see exactly the conversation between Mr. Knight and myself. There was also something stated by the AG's office that criminals do things at night. Well, it was at night, based on the testimony, that masked men entered into his cell. That was at night. You heard Mr. Knight invite the district attorney to the hearing to make a record. Mr. Knight came to the district attorney's office and asked for our participation so that he could make a record for his client. And it just so happened that at that hearing was Mr. Butler and his new charge. And we began to have a legal argument, as we always do as lawyers. We have legal arguments, and we can disagree. Those arguments were legal arguments in open court. When the statement was obtained from Butler, that was during the daytime, it was simply to find out the truth. And as you have learned, grand juries are secret proceedings. Secret proceedings. has a right, the AG's office, or anyone else, has a right to snoop into our investigations and what we're talking about, and what charges or what not charges. They don't have a right to snoop into anyone's investigations, what we're talking about.
2 minutes remaining, Mr. Smith. 2 minutes.
That would be, and is, a crime to snoop into someone's grand jury investigations. So again, this is very obvious that this is a high-tech mission. And everyone who came to me about this case, Mr. Rundle and many others, they came to me about this case. And when they got in court, they left me hanging. That's all. Everyone that got up, Mr. Rundle, everyone had a lawyer or multiple lawyers standing right there by the AG's office. They represent the judge who was sitting where? At the AG's office.
We're going to take care of it. The judge has his own lawyer, not representing the AG's office.
So stand.
So the evidence is very clear here, ladies and gentlemen, here, what this case is really about. I did not commit a crime.
Objection.
I was my duties.
All right, sustained. Just argument, please.
I was doing my duties as a
Objection, Your
prosecutor.
Honor. Good testimony.
Sustained.
And I think the evidence will show that. And again, how can I conspire with Mr. McBride and Mr. McBride's case has been dismissed? Unbelievable.